Protesters marched in Chicago and in cities around the country this weekend. This after a jury last Friday found Antioch resident Kyle Rittenhouse not guilty on all 5 charges. Rittenhouse's defense lawyer Mark Richards says he believes it was a clear-cut case of self-defense when Rittenhouse shot and killed 2 men and wounded another with an AR-15 rifle during unrest in Kenosha last summer.
He didn't want to kill anybody, and he was left with a terrible choice. And he exercised that choice, which was found to be lawful.
So what does the verdict say about self-defense, gun laws, and the threat of vigilantism in the U.S.? Joining us now with more are Dan McConkey, a professor at Northern Illinois University's College of Law. McConkey is also a former state and federal prosecutor. And Chicago defense attorney Tony Thedford, past president of the Illinois Association of Criminal Defense Lawyers. Welcome both of you back to Chicago tonight. Dan McConkey, as a former prosecutor, your reaction to the verdict that the jury came back with on Friday?
It wasn't much of a surprise to me. The prosecution bears a heavy burden of proof beyond a reasonable doubt, and here, the defense was able to present an effective self-defense, a plausible self-defense scenario based on pretty compelling testimony from the defendant himself and a lot of video footage.
And Tony Thedford, the jury did deliberate into day 4 on this case. Are you surprised at the acquittal and not at least perhaps one of the lesser charges that they could have considered?
Right. Thanks for having me again. And I do agree with the professor relative to this being an easy self-defense case, at least relative to the defense, because there was enough information there for the defendant to properly employ self-defense as a defense, and his testimony was crucial to securing that acquittal. I am surprised to some extent, only because I assumed that a jury that deliberated that long would come up with a compromise verdict. And I believe that as a compromise verdict, they would find one of the lesser charges. My belief from the beginning was that this would not be first degree because there was this element of self-defense. But I thought that the jury might find a compromise, not because a compromise was required here, but because I believe that the jury saw the weight of the decision that they were making. And having deliberated for that long, I assumed that they were wrestling to get to that conclusion. So I was shocked when all 5 counts he was found guilty of.
Certainly a case that had obviously national reverberations. Dan McConkey, what was the key evidence besides the testimony from Rittenhouse that made the case for self-defense in this trial?
I think the key evidence is the videotape footage. There's so much footage, drone footage of all the shootings of all 3 of the victims here, and it helped the defense to focus in on just those few moments before the shootings. For the prosecution to persuade the jury that Rittenhouse was the aggressor, which would defeat a self-defense claim, it requires the jury to think about the larger situation. But when you've got that video that's pretty clear that in the moments before there are people coming at Rittenhouse, Huber is hitting Rittenhouse over the head, Grosskreutz is approaching him with a pistol, it puts them right in the moment, and it made it easy for the defense to frame it as self-defense.
Although, Tony Thedford, one of the self-defense claims was that Rittenhouse was afraid his gun could be taken from him and used to kill him. Is that a slippery slope there?
I think absolutely. The defense was successful, and at trial they were successful in framing this from the moment of the exchange between Mr. Rittenhouse and the 2 deceased gentlemen, as well as the gentleman who was shot and fortunately survived. But one can frame this broader from the time this young man brought this gun into the state of Wisconsin, or obtained the gun before he went out there on the street to presumably protect what he believed was protecting property somehow. So again, I think that broadening the scope of this, who becomes the aggressor or what the intent was of Mr. Rittenhouse actually becomes muddled, and it becomes far more muddled than what was presented to the jury at trial. However, I am not arguing that the jury should have had more information. There are certain rules when we're talking about trial which disallow certain information to come in because we want to ensure that the defendant has a fair trial. And here the court made a decision to cut off that timeline in terms of what the jury was to receive to that point, frankly, of the exchange between the defendant and the deceased in this case, and as well as the other victim.
Certainly just appeared to be like a fog of war situation, or at least that's how the jury saw it. Dan McConkey, is there any difference in terms of self-defense standards in Illinois versus Wisconsin? AKA, would it have been the same case had it happened in Illinois?
I don't think the law in Illinois is in any important respect different from the law of Wisconsin when it comes to self-defense. I think the result, if this had all happened on our side of the border here, I think the result would have been the same.
Although, Tony Thedford, there are certain standards that have to be met. And what about open carry laws in Wisconsin? Might that have been different had it happened in Illinois because of the different gun laws here?
Well, there was an assumption that Mr. Rittenhouse was lawfully carrying that gun. That assumption was made by law enforcement. That assumption was made by those people who could have intervened earlier by simply asking questions of this young man walking up the street with such a dangerous weapon. But when you factor in the fog of war piece, when you factor in the abundance of activity that was happening out there that night, again, these were protests, and there was a bunch of activity police were involved in. But ultimately, I think this comes down to the assumption that this young man who was white was somehow safe and justified in carrying his rifle at the time he was carrying it. And the same scrutiny would not have been paid to someone if this young man were a black man. That is simply my belief, and I think that's pretty obvious based on sort of the history of what happens in our country.
And Dan McConkey, I want to pick up on that issue of race. Do you agree here that race did play a role? And is there evidence to suggest that black men do not get the same or get a higher level of scrutiny typically than white men?
Yeah, I was just about to chime in anyways and just say I agree with Tony. I mean, of course, when you look at just one case, it's hard to isolate race and say that was the deciding factor. But you know, I know Tony works with a lot of cases, and I've worked with a lot of cases over my career. And I do think it's hard to imagine a young black man walking the streets that night with an AR-15, and the police are just almost treating him as one of their own. I can't imagine that, and I haven't seen that before.
Certainly.
So I think race is a factor here, and I think that's why a lot of people are upset about this verdict. On one level, you say, well, it's a white defendant who killed white victims. What does race have to do with it? But I think for people that live with the reality of an unequal justice system, it stings to see a result like this. It's a reminder that blacks and whites don't get the same level of justice.
Certainly a lot of questions as to the conduct of the law enforcement that night on the scene. Tony Thedford, are you worried about the precedent that this finding, that this verdict could set for people who decide that they want to be armed at protests in the future?
Well, one could argue that precedent was set in this country hundreds of years ago in terms of the disparate treatment between a young man who is white, like Mr. Rittenhouse, and a potential different young man who was black. So that precedent has long been set in terms of the expectation that the treatment will be different. That, frankly, is the tragedy of this case. In terms of it setting precedent, in terms of vigilantism, in terms of people's belief that they can then carry a gun into a similar situation with impunity, if in fact tragedy occurs similar to what happened to Mr. Rittenhouse's case. I think there is a slippery slope, but I think that this has more to do with not the courts and the court's permission to allow a person to act in a manner that results in the deaths of others. I think that has more so to do with the expectations of the gun carrying population. And frankly, some belief perhaps that just because one may have the right to carry a gun, even in open carry states, that then allows behavior based on their own discretion to fire that gun, claiming self-defense, when in fact it could be argued that but for the presence of that gun in the first place, there would never have been a situation that would have resulted in this outcome.
A lot of questions still swirl around here, and people will be talking about this case for a long time. But we'll have to leave it there. Our thanks to Dan McConkey and Tony Thedford. Thanks so much.
Thank you for having us.
Thank you.